It's the appointed time, and we have a quorum. Please invite the administration to join us. Welcome. On the 21st of April, in our last meeting, the Bills Committee continued with the clause by clause. The administration has provided a response paper to questions asked last time. Please refer to LC paper number CB bracket 21359/14 to 14 bracket 02. You may refer to paper number CV bracket 21359/14 to 15 bracket 01 for the list of follow-up actions arising from discussions at the last meeting. Perhaps I will ask the administration to quickly take us through the response paper. Mr. Kwok? On the 21st of April 2015, members asked some questions, and we have given a written response. And let me go through the salient points. In relation to the licensing requirements of property management practitioners, as we've said last time, in order to regulate the sector, we have established an advisory committee, and under it there are working groups and subcommittees. In December 2014, they convened a meeting and have come up with some preliminary proposals about the basic requirements that will cover the experience, professional qualifications, and whether they are fit and proper persons to hold such a license. In a meeting, the advisory committee has confirmed the points raised by the subcommittees. We have reached a consensus with the trade that the licensing requirements should cover three areas: experience, qualifications, and professional qualifications. After last time, we have spoken to the relevant bodies and professional groups. They agree with the principle and direction of the licensing requirements, that is, professional qualification, academic qualification, and experience, and years of service. And in relation to the requirement for Tier 1 PMPs, professional bodies have expressed some views. We'll continue to talk to these professional bodies, and we will revert to the committee shortly. And in relation to Clause 25(1)(b) and Schedule 2, the bill empowers the authority to, after at the end of the hearing, if the authority is satisfied that the licensee has contravened the relevant regulations, there can be a penalty imposed. It is not a common occurrence. So when it comes to a fine in the disciplinary hearing, say for example, for surveyors, social workers, traditional Chinese medicine practitioners. however, is for the authority to decide whether to impose a fine, and it can be written in the principal legislation. We would like to include the penalty in a schedule by way of a subsidiary legislation because we would like to give the flexibility to the authority to set the maximum penalty to be imposed and revise it from time to time. We think this is an appropriate approach. In relation to disciplinary hearings, under the bill, the authority may, taking into account the severity, the gravity of the case, and make a direction under 23B2 to hand the case over to the disciplinary committee to hold a hearing. Serious cases will be handled by the disciplinary panel, and minor ones will be handled by the authority. And there should be 3 members in the disciplinary hearing, in the disciplinary panel to ensure fairness. And there are also other issues raised, say for example the number of graduates every year, and views expressed in relation to clauses 30, 31 and 36, where we will supplement when the time comes. Any follow-up questions to the administration's response? Mr. Wong Kok Heng, 5 minutes, question and answer included. In relation to the first part, that is paragraph 1A and B under CB bracket 21359/14 to 15 bracket 01. Seven professional bodies contacted me. They asked me to ask some questions on the admin's response to this part. They point out that on the 29th of December 2013, there was not enough time in the meeting to exchange views. The administration said that they have consulted professional bodies in the trade. They actually would like to communicate further with the administration to dispel any possible misunderstanding. I noticed that the government said at the end that they would continue to communicate with them. I hope the government will hear what I said about communication, because they don't see eye to eye on this issue. The 7 professional bodies said that when it comes to those who have worked for a very long time in the sector but they don't have the academic qualification, perhaps a one-off exemption can be given to them. The Home Affairs Department, the Home Affairs Bureau has yet to give them a clear answer. The professional bodies are not happy with it, and they would like to hear from the administration. My third point is from me personally. The 7 professional bodies have strongly made their request, perhaps because they have not, you have not properly communicated with them. I hope that the government will undertake to communicate with the 7 professional bodies in order to forge a consensus. Actually, my ward office has received similar requests from the same bodies. And they've already been mentioned by Mr. Wong, is his first 2 points. Mr. Kwok. Well, Mr. Wong mentioned about the meeting on the 29th of October 2013. It was a detailed discussion about qualifications of licensees. The professional bodies have given us detailed information, and the minutes of the meeting have been given to the professional bodies. At this stage, we set the directions for the general directions, and we've communicated with them, and they confirmed that they share the same view with us when it comes to the general direction and principles. And it's only when it comes to the details that they have to be further ironed out. We'll continue to talk to the professional bodies. And I'd like to say that when it comes to the licensing regime, the authority will establish the regime by way of a subsidiary legislation. And there is still quite some time before the subsidiary legislation is formulated. Before or after the authority is established, we will continue to talk to the professional bodies. In relation to a one-off exempt in the paper from the last meeting, paragraphs 8 to 10, we have responded. There will be a 3-year transitional period for people who are already working in the property management trade, and they have quite a lot of experience but have yet to attain the academic or professional qualification. They can apply for a provisional license, and then they will perhaps take some professional courses. And after they have reached a certain professional standard, they will be given a proper license. This is a transitional arrangement. We have already communicated abundantly with the 7 professional bodies, and we have got their strong support. The main consideration of this arrangement is that, on one hand, we would like to help those who are already working in the trade for a long time to continue to provide a service after they have met the relevant requirements. And on the other hand, we will be able to maintain professional standard of the practitioners in the trade, because it is very important. This arrangement will ensure the credibility and fairness of the regime.
Chairman, I would like to follow up briefly. Well, it will be brief, Chairman. It's a request. For the 7 professional bodies, as you know, they made serious requests. They gave us comments. They meant it. So I hope that the government would undertake that they will continue to have in-depth communication with the professional organizations. Well, they expressed these views to me just a few days ago. That is on the Labor Day celebration. So I hope that the government can undertake that. You will communicate with these professional bodies as soon as possible. Yes, I understand that many professional organizations are involved, and also several universities are involved. Opinions have been expressed about that. So I hope the government will talk to them as soon as possible. Maybe a meeting should be held so that you can update them on the latest progress. And also you can exchange views with the stakeholders. And you can also report back to us after that meeting. Well, Chairman, actually before the Labor Day, I talked to the representatives of the 7 professional bodies. I understand their concerns. And at that meeting, I already said that I will continue to communicate with them. So I can promise members that we will continue to talk to these professional organizations concerning the licensing regime. Yes, I like to hear that, but I hope that after the next meeting, you will revert to us. Well, you met with them, and I believe that it was a very formal meeting. I met with the major representatives of the 7 professional organizations. Some of them were chairmen of those organizations. So if we further discuss with them and the consensus reached, I will definitely report back to members. Yes, please give it a report in writing after your meeting. We want to know what consensus you have forged. Mr. Wang said there might have been some miscommunications or even misunderstandings. Next, Ms. Claudia Mo. Thank you, Chairman. I also would like to ask a question about exemption under Clause 30. Now, because this is in black and white, however, last time we saw a lot of confusions. That is, who's going to be investigated or who's going to assist the investigation. And then according to Clause 18, you can enjoy immunity. So I want to ask about this immunity. Where does it come from and who's going to authorize it? I think it's just a basic technical question. You can just change the wording. However, ever since the last meeting, you have never given me a proper answer. I hope this point can be clarified. And for the next meeting, can you give me an answer? Because this has confused me for quite some time. I thought you could have given me an answer very quickly. Well, do you have a timetable for answering questions? I remember last time we spent quite a lot of time discussing this. So who's going to answer this question now? Thank you. Mr. Kwok? As Ms. Mo pointed out, last time she also asked a lot of questions about this because we want to give you a more accurate answer. So we need time to look into that. At the next meeting, we will give you an answer. Ms. Mo, any follow-up? No? Next. Vice Chairman, Mr. Wu Chiwai. Thank you, Chairman. A simple question. Just now, we talked about the 7 professional bodies. Also, we know that they are very concerned. We've heard the government's answer. It seems that it's because we still lack a lot of details, so that's why there are so many questions. Now, because under this principal legislation, there will be a number of subsidiary legislations. So I want to ask, when will you be providing the details so that we would know how we should go on scrutinizing this piece of legislation, and we want to know how the principal legislation is going to be related to the subsidiary legislation. Thank you, Chairman. For the subsidiary legislation, they will be provided to members in batches. And of course, some of the legislation will be formulated by the Future Property Management Services Authority. We are doing the work and we will provide information to members as soon as possible. Chairman, is there a timetable? Because we have been scrutinizing this bill for almost 8 months. It's quite a long time. And we've heard that answer just now for several times. So can you give us a timetable? Will you give us those subsidiary legislations before we end the scrutiny? Mr. Kwok, you say that they will be provided to us in batches. So do you have a plan? When will the first batch come? Thank you, Chairman. We are actually carrying out the work, so we hope that we can tell members as soon as possible. And we will provide the information to members as early as possible. Well, Chairman, this legislative session will end on the 8th of July. We only have 2 months left, so we really have a very tight schedule. So do you think that we need to continue to scrutinize this bill in the next session? Well, according to the present progress, I think we need to continue to scrutinize the bill after the summer break. And I hope that the government can provide further information or CSAs to us. And at that time, we will be having more detailed discussions. Now we are in the year 15 to, we hope that we can finish this scrutiny in the year 15-16. Well, Chairman, I just want to say that we have a very tight schedule, and I think the public is looking forward to this piece of legislation. However, up to now, I still do not understand where the obstacles are. Now, of course, if there are no disputes about the subsidiary legislation, that would be fine. However, if there are disputes, it will take an even longer time for us to scrutinize all this. Mr. Kwok, can you go back and take a look at it? When can you give us a more detailed timetable? Yes, we'll follow up on that. Chairman, I want to say something else. Can our clerk give us a list concerning the questions that the government hasn't answered yet, so that while we scrutinize the bill, we'll have a clearer picture? At the last meeting, some members have also talked about this. The Secretariat will follow up on this, because for this bill, it involves a number of ordinances. So we want a list, and then members can have a better understanding of the situation. But the Secretariat will follow up on this. Members, concerning the government's response, do you have any questions? Mr. Chen Kim-po, Chairman, I would like to respond to Mr. Wu Chi-wai. I have the same concern as his. For property management, we want the practitioners to be more professional, and we want a disciplinary mechanism. So this piece of legislation is very important. I do not want it to be delayed. So if members have questions, I think they can continue to ask the government, even outside these meetings. We hope that property management can be more systematic as soon as possible. I hope the government can speed up. Members are concerned about the subsidiary legislations, and I want to get more basic information as soon as possible. And also, last time we talked about the maximum fine level, and members expressed concern about revising the levels. The PMSA will be authorized to revise the levels. Mr. Kwok, you said that you have taken reference from other regulatory frameworks, and it seems that they do not impose a fine. Members are concerned that if the power is given to the PMSA, would it be very difficult to check and balance? How can you ensure that there will be proper check and balance? I think we are all very concerned about this. And also about revising fine levels in other pieces of legislation. Most of the time, those kind of amendments will have to come back to the Legislative Council. However, for these pieces of legislation, it seems that the PMSA can adjust the maximum fine level. So, Mr. Kwok, can you supplement? Thank you, Chairman. With regard to your question, yes, we see that for other registration systems, they may not impose a fine. And for the real estate agency regulatory system, the fine is included in the relevant piece of legislation. And if that is the case, then the principal legislation would have to be amended if the fine level is to be changed. Now our fine is included in the schedule. But according to Clause 63, it's not that the PMSA can revise the level by itself. It would have to put a notice in the Gazette, and also this has to go through LegCo by negative vetting. So the PMSA cannot change the fine level unilaterally. Thank you.
Mr. Chen Kim-po, sorry, I would like to supplement what I said. What I meant was members very often could not get an answer from the administration. That's why they have to ask questions in other meetings, and very often I would just call them. If they can't give us an answer, we will continue to ask them. There are many avenues, not just this meeting. And you've promised us a lot of things. Say, for example, amendments, you will have to be on top of it. I believe the government has heard you. We see eye to eye with members because we would like to expedite the process of this bill so that the trade will be regulated. We have done a lot of work when it comes to amendments, and we will continue with our work, and we'll give you the information as soon as possible. If there are no other questions, let's continue with the clause by clause. Last time we were at clause 36 bracket 6. It's part 6. Let's start with clause 37. It's in the blue bill page 2798. That is clause 36. It is in relation to the hearing before appeal tribunal. We will start with subclause 7 of clause 36. It says that a party to the hearing may, subject to any order made by the chairperson of the tribunal, be present at the hearing and may participate in person through a legal representative or with the consent of the chairperson of the tribunal through any other person. Subclause 8 says that for the purpose of subsection 7b(1), a company is to be regarded as participating in person if it participates through any of its directors. And subclause 9, subject to other provisions of this section and any regulation made under section 38, the chairperson of the tribunal may conduct the hearing in any manner the chairperson considers appropriate. Mr. Wong, please continue if there are no questions. Oh, Mr. Wu Chi-wai, I would like to ask, subclause 9. It says the chairperson may conduct the hearing in any manner the chairperson considers appropriate. When a decision is made, is there any mechanism that will restrict the power of the chairperson, and will there be a list of the different manners when a hearing is to be conducted? If it is an open hearing, there are provisions regulating that. And if it is in private, then certain arrangements will have to be put in place to consult specific parties, etc. And when it comes to the details, say for example, location and time is for the chairperson to decide. In the future, the authority will, by way of guidelines, set down some basic requirements. But the chairperson has the power to conduct a hearing in an appropriate manner. Well, Clause 38 talks about the secretary. I think the secretary refers to the Secretary for Home Affairs. Is that right? But we are at 36. Yes, but Clause 9 talks about Section 38, and Clause 38 talks about the Secretary may by regulation prescribe the procedures for the hearing of appeals. That is, if the Secretary has prescribed the procedures for the hearing, then the chairperson may conduct the hearing in any manner the chairperson considers appropriate. It seems that when it comes to in any manner is a power that is unfettered. Is it the case that even though it says in any manner, there are still some limits? Well, Clause 38 talks about a secretary, which refers to the Secretary for Home Affairs may prescribe the procedures. There are similar arrangements when it comes to other regulators. Say, for example, then it will be circulated to the relevant parties and the details will be set out in subsidiary legislation. There may be some arrangements related to operations, say, for example, where and when, and what are the parties. These specifics may not be set out in a subsidiary legislation. Is for the chairman to decide by way of discretion. That means under Clause 38 there will be subsidiary legislation setting out the procedures for appeals, and the chairman may conduct the hearing in any manner, which means details related to the hearing. Well, subclause 9 says, subject to other provisions of this section and any regulation, there is actually a framework. When it comes to actual operational matters, the chairman may make decisions. Mr. Wong, let's continue. Clause 37 is about the decision of appeal tribunal. It says that an appeal tribunal hearing an appeal may confirm, vary or reverse any decision, finding or order to which the appeal relates. Subclause 2 stipulates that the decision of the tribunal is final. Legal advisor. Thank you. We see that for Clause 37, there is no provision related to the cost incurred in the appeal tribunal hearing. However, when it comes to a disciplinary hearing, there are provisions that caters for the cost incurred. Do we need to add similar provisions here? Mr. Kwok? Thank you. Well, 37 subclause 1 reads that the appeal tribunal may confirm, vary or reverse any decision. Our understanding is that it includes decisions related to cost as well. Legal advisor? Well, actually, no. Because it only covers the cost of the disciplinary hearing, that is the first hearing, but not the cost incurred during the appeal hearing. And perhaps we will I will talk to the law draftsman before we revert to the committee, legal advisor. Back to clause 25, bracket 2. When it comes to cost and expenses, we see that there can be legal representatives in these hearings. So when it comes to cost and expenses, does it relate to legal costs? Perhaps we will give you an answer next time in one go. Mr. Wong, please continue. Clause 38, regulations for hearing of appeals. This empowers the Secretary of the Home Affairs to, by regulation, prescribe the procedures for the hearing of appeals. I think members are concerned about the procedures, and they would like to know about it as soon as possible so that they can comment on it. Clause 39, offenses relating to appeal. Bracket 1, a person commits an offense if the person at the hearing before an appeals tribunal gives any evidence or provides any information or document that is false or misleading in a material particular. And B, the person knows that or is reckless as to whether the evidence, information, or document is false or misleading in a material particular. And if a summons is issued under Section 36, bracket 1b, a person commits an offense if the person without reasonable excuse fails to comply. And a person who commits an offense under subsection 1 or 2 is liable on conviction on indictment to a fine of $200,000 and to imprisonment for 1 year or on summary conviction to a fine at level 6 and to imprisonment for 6 months. Any questions? Mr. Wu? May I clarify? Under what circumstance will someone be charged on indictment? And under what circumstance when someone is charged by way of a summary procedure? That depends on the facts of the case. If the defendant may reoffend, and if the court would, and if they would like to get a higher sentence, then it will be on indictment. And if it's a first offender, it may be by way of a summary offense, and the case will be heard at the magistracy's court. So who is to make the decision? I think that's the question of the member. It's to be decided by the prosecution. Mr. Ip Kok Him. 39(1)(b). Well, 1A is very clear. It's the person who gives evidence. B relates to the person who knows that the evidence, information, or document is false. To whom do you refer to? To whom do you refer?
B 嘅佢進行呢？
Under what circumstance will the person be doing what B says? Say, for example, if it's perjury, then it's clearly a criminal offense. Who do you refer to under B? Well, B has to be read together with A. The person gives false evidence, and at the time, he or she knows that it is false. So it's and. So it's the person in the hearing, the one who provides false evidence and knowing that the evidence is false, choose to do so. Mr. Tse, Paul Tse. 36(1)(a), the appeals procedure. It can be done by declaration, by evidence on oath, and for indictment, the maximum fine is just 200,000 and 1 year. But if we refer to the crimes or the criminal procedures ordinance, giving false evidence under oath, 7 years. And if it's not done on oath, say for example it's by affidavit or affirmation, it still attracts an imprisonment of 2 years. So do you think that if the case is heard before a magistrate, then the offense of giving false evidence is minor compared to other levels of courts? This is consistent, this penalty. We have also taken reference from similar provisions of other regulators. Taking into account Mr. De's point, we will refer to the Criminal Procedures Ordinance to see if we can give you further information. Can you confirm? Whether it is the original hearing or on appeal, giving false evidence will be subject to this provision and not the relevant provisions under Criminal Procedures Ordinance. Can you give me an answer next time as well? Next, Mr. Wu Chi-wai. This relates to an appeal. Are there similar arrangements in other legislation, other pieces of legislation, that there will be a differentiation, that is on indictment or a summary procedure? I can't imagine that someone will inadvertently provide false information or false evidence in an appeal. So how come Well, I think because if it's a summary offense, then probably you're referring to someone who does it inadvertently. This is an appeal. Of course, you would like the person to attach importance to the procedure. However, there is a provision of a penalty under summary offense. The penalty is lighter. Are there similar arrangements under other pieces of legislations? We take out the summary conviction. How does it affect the completeness of the law?
Mr. Kwok, in the course of appeal, there's only not one side. That is, there's will be an appellant and there will be another party. So when it comes to carelessness, it's not just about one party. And also someone may give false evidence. So with regard to completeness, we want to keep it this way. That is, there will be conviction on indictment or on a summary conviction. For summary conviction is about less serious offenses. However, we can also use conviction on indictment if the case is more serious. So is there similar arrangements in other pieces of legislation? At the next meeting, I will provide you with relevant information for reference. Mr. Wang, please continue. Now, let's move on to Part 7, Property Management Services Authority. Clause 40, Establishment of Authority. Subclause 1, a body corporate is established with the name Property Management Services Authority in English and 物業管理業監管局 in Chinese. The authority has perpetual succession under its corporate name, must provide itself with a common seal, and may sue and be sued in its corporate name. Subclause 3. Schedule 3, which contains constitutional, administrative, and financial provisions, has effect with respect to the authority. Thank you, Chairman. Mr. Wu Chi-wai, any question? If not, let's continue. Mr. Wang. Clause 41. Principal functions of authority. The principal functions of the authority are A. To regulate and control the provision of property management services by the licensing of property management companies and property management practitioners. B. To promote the integrity, competence, and professionalism of the profession of property management services. And C. To maintain and enhance the status of the profession of property management services. Clause 42. Powers of authority. The authority may do anything it considers appropriate for it to do for or in relation to the performance of its functions. Mr. Wu Chi-wai, any questions or comments? If not, Mr. Wang, please go on. Clause 43. Sorry, I want to go back to part 6. It says that one chairman and 11 other members. Well, have you specified the background for the chairman? Mr. Kwok, can you supplement? Which provision are you talking about? Clause 32. Appeal panel. For clause 32, it's about the appeal panel, and it says that it will consist of one chairperson and 11 other members. However, when I read part 6, it hasn't told me anything about a chairperson. What kind of conditions does he have to meet before he can become a chairperson? I thought this question has been raised before. Yes, at the last meeting, a member also asked the same question. As for appeal panel, it will consist of one chairperson and 11 other members, and they will be appointed by the Secretary for Home Affairs. In the future appointments, well, first of all, there must not be conflict of interest. Well, they will be people from different sectors, but they should have knowledge of the property management services. And also, at the last meeting, we explained that they should be people from all walks of life, so we shouldn't specify their requirements or backgrounds. We have also taken reference from other relevant pieces of legislation. Chairman, why am I a bit concerned? Because if you look at clause 39, offences relating to a appeal, the appeal panel can sentence a person to a year's imprisonment. So if we look at clause 34, every time a 3-person appeal tribunal will be formed. But if this person has no legal background, and he does not meet the requirement of a magistrate, if you ask him to make a judgment, and as a result, the person will be imprisoned for 1 year and be fined for $200,000, then I will have huge reservation. Now, for clause 39, offences relating to appeal. If a person commits an offence of giving false evidence, then he will have to go to court. It's not the chairman of the appeal panel that makes the judgment. However, what is the process like? For this appeal tribunal, each time there will be one chairperson and 2 individuals as the other members of the tribunal, and they are to make a decision. That is, during a hearing before the appeal tribunal, a person gives false evidence. Then they will be referring the case to the Department of Justice or what? So I want to know what the operation procedures are. Thank you. When it comes to actual operation, well, when it comes to a hearing before a appeal tribunal, if a person is suspected to be giving false evidence, then enough evidence would have to be collected before the case can be referred to the court. So the appeal panel will have to cooperate with the police, and then further evidence will be collected. Of course, the Department of Justice legal advice will also be sought. That means that the appeal tribunal will call the police for help, and then the police will conduct a criminal investigation. After the investigation, the file will be submitted to the Department of Justice, and the Department of Justice will decide as to whether prosecution will be carried out in accordance with the indictment or summary procedures, right? Well, the appeal tribunal, if it discovers irregularities, then first of all, well, it will need prima facie evidence. It will collect evidence first, and if there is a need for higher power, then the appeal tribunal may call the police. Then the police will carry out investigations, and the police would assist to follow up. And afterwards, like what Mr. Leung says, the police, after collecting enough evidence, will seek advice from the Department of Justice. I would like to ask our legal advisor. Under the Property Management Services Bill, well, if this bill is to be passed into law by LegCo, then for Clause 39, it will decide how an offender is to be punished. The appeal tribunal will not be the authority to do that. Well, the appeal tribunal will have to call the police, and then the police would follow its routine criminal investigation procedures, and then it will seek advice from the Department of Justice. The Department of Justice will decide as to whether a prosecution will be initiated. So this arrangement is normal, legal advisor? Under this piece of legislation, the appeal tribunal does not have the power to penalize a person who commits an offense under Clause 39. So I think the administration's explanation is acceptable, because the appeal tribunal does not have the power to institute criminal prosecution. For Hong Kong's criminal laws and case laws, I think there are sufficient provisions to govern this. That is, people cannot give false evidence or forged documents. So why do you have to specify here under the Property Management Services Bill? Is it necessary? I think Mr. Porcher has also asked a similar question. Here are some penalties, and there are already existing laws concerning the giving of false evidence and forging documents, and there are relevant penalties. And just now, Mr. Kwok has promised us that he will go back and take a more in-depth look, and then he will give members a reply. So with regard to Mr. Leung's question, do you want to supplement anything? Yes, just now I promised Mr. Chair that I would provide the relevant information. Under Cap 511, Section 55, there are similar offences. So the arrangements are similar and the fine levels are the same. So this is not the first time that we do so. This arrangement has already been in place in other pieces of legislation. Members have asked a number of questions, so I hope the governments can get more information and then submit them to members so that we can follow up. Mr. Wu Chi-wai. Mr. Elenau. Well, for clause 39 is offences relating to appeal. As for 28 is offences relating to disciplinary hearing. So if we are talking about a forged document, and it's been forged ever since the disciplinary hearing, he's not happy with the judgment, and then he goes to the appeal tribunal, he uses the same documents.
Does it mean that there will be two offences, one under 28, one under 39? So he will be sentenced to 1 year under 28 3A and under 39 3A another year. So there will be altogether 2 years because of the two offences. Is that right? I just want to know about your idea. Is that the design? We will seek legal advice before we answer Mr. Leung's question. That is whether there will be 2 counts of offences relating to the same instrument. So the disciplinary hearing under clause 28 and the appeal tribunal hearing under 36 will be seen as 2 separate proceedings, and you will leave it to the court to decide whether to impose the sentence concurrently or consecutively. I just want to know about the design. As I said, we will seek legal advice before we answer members' questions. Mr. Wu Chi-wai, a very simple question. This appeal panel or appeal tribunal, is it voluntary or will they be reimbursed? And if it's the latter, will there be provisions under the bill to ensure that members of the appeal tribunal will be suitably remunerated, say for example to pay for their transportation? As far as I know, in similar appeal tribunals, there is no explicit provisions that cater for remuneration of members. But usually when certain conditions are met, they will be reimbursed for their transportation expenses or other expenses. But this is an administrative arrangement. If there are no follow-up questions, we'll continue with 42. Thank you. I think it's 43. Part 3, 43. Clause 43 stipulates that the authority is not a servant or agent of government and does not enjoy any status, immunity, or privilege of the government. Please continue, Mr. Wong. 44. Immunity from civil liability. Subclause 1. A person to whom this subsection applies is not civilly liable for an act done or omitted to be done by the person in good faith in performing or purportedly performing a function of the authority under this ordinance, or in exercising or purportedly exercising a power of the authority under this ordinance. Subclause 2 states that subsection 1 applies to 4 types of people: a member of the authority, B, a member of a committee of the authority, C, an officer or employee of the authority, and D, a person who is performing any service for the authority under a contract for services. Subclause 3 stipulates that subsection 1 does not affect any liability of the authority for the act or omission. Any questions for 44? Mr. Wong, please continue. 45. Is the register of interests. It stipulates that a member of the authority must disclose to the authority any interest that the member has, which is of a class or description determined by the authority under subsection on the member's first appointment at the and they will be able to find relevant particulars in the register, and they will be able to inspect the register after certain conditions have been met. These are the details. A. On the member's first appointment to the authority. B. At the beginning of each calendar year after the member's appointment. C. On becoming aware of the existence of an interest not previously disclosed. And D. After any change occurs to an interest previously disclosed under this subsection, the member must disclose to the authority such interest. So clause 2 relates to a member of the committee who is not also a member of the authority. The member must disclose to the authority interest under subsection 3A on the member's first appointment to the committee, B at the beginning of each calendar year after the member's appointment, C on becoming aware of the existence of an interest not previously disclosed, and D after any change occurs to an interest previously disclosed. Subclause 3 is for the purpose of subsections 1 and 2, the authority may determine a class or description of the interests required to be disclosed, determine the details of the interest required to be disclosed and the manner in which the interest is to be disclosed, and C from time to time change any matter determined under paragraph A or B. Subclause 4. The authority must keep a register relating to any disclosure made under subsections 1 or 2. 5. If a person makes a disclosure under subsection 1 or 2, the authority must record the person's name and the particulars of the disclosure in the register. And if a further disclosure is made, the authority must record the particulars of the further disclosure in the register. 6. The authority must make the register available for inspection free of charge. A. At the offices of the authority during ordinary business hours. B. Through the internet or a similar electronic network. And C. In any other manner the authority considers appropriate. Subclause 7. A person may, on payment of the prescribed fee, obtain from the authority a copy of the whole or part of the register. 8. The authority may by regulation prescribe the fees payable for a copy. Mr. Ip-Kok-Kim. Thank you. 45, 1 and 2 can be combined. just say it includes a member of a committee who is not also a member of the authority. But I agree that this is just a different way of expression. 3A. Determination of the class or description of the interests required to be disclosed. Can you give us some examples? Mr. Kwok. We have taken reference from similar provisions, say for example Section 15 of the Real Estate Agents Authority. This leaves flexibility for the authority to decide which class or description of the interest are required to be disclosed. But I just want to know what class or description. Can you give me some examples so that I have an idea? Mr. Kwok? Well, I may refer to the approach of the Real Estate Agents Authority for your reference. Mr. Ip also mentioned about 45(1) and 2. It seems to be less than satisfactory. You can combine the two, but I don't insist. It can be separated, but still it can be combined. Mr. Kwok, we thank Mr. Ip's views. We will talk to the draftsman to see if it will be clearer if we combine the two. Mr. Wu, thank you. I would like to draw your attention to 45(6). That is, the authority must make the register available for inspection. And 7 says that on payment of a fee, a person may obtain a copy of the whole of the register. And it also talks about making available the register on the internet or similar electronic network. Does it mean that the information made available in a hard copy or in electronic form will be different? But they are exactly the same. One is put at the offices for people to inspect, and the other one is made available on the internet. So one can use electronic means to copy the information thereon from the internet, right? Yes. No fees will be charged if a copy in electronic form is obtained. Or is it the case that you can only get a hard copy from the authority? Or is it the case that you will only be charged a fee when you obtain a copy from the authority? Well, the idea is that if the authority is involved in the provision of the copy, then there may be costs related to, say, for example, photocopying. So there will be a fee. If you do it yourself on the internet without involving the authority, then it will be free of charge. Any other questions from members? If not, Mr. Wong, please continue. 46. Disclosure of interests. If a member of the authority has a disclosable interest in any matter under discussion at a meeting of the authority, the member must disclose the nature of the interest at the meeting, and the disclosure must be recorded in the minutes. And these are the specific provisions. 1. Definition of disclosable interest. It means A. A pecuniary interest, whether direct or indirect, or B. A personal interest greater than that which a person has as a member of the public. Two, if a member of the authority has a disclosable interest in any matter under discussion at a meeting of the authority, the member must disclose the nature of the interest at the meeting, and the disclosure must be recorded in the minutes. 3. The following provisions apply in the case of a disclosure under subsection 2. A. If the disclosure is made by the member presiding, the member must vacate the chair during the discussion. B. If so required by the majority of the other members present, the member, including one who has vacated the chair under paragraph A, must withdraw from the meeting during the discussion. C. Unless the majority of the other members present determined otherwise, the member, including one who has vacated the chair under paragraph A, must not vote on a resolution concerning the matter under discussion or be counted for a quorum. 4. If a matter is being dealt with by circulating written resolutions under Section 13 of Schedule 3, and a member of the authority has a disclosable interest in the matter, the member must disclose the nature of the interest by attaching to the papers being circulated a note recording the disclosure. 5. For the purposes of Section 13(1)(c) of Schedule 3, if a member of the authority has made a disclosure under subsection 4, the member's signature, if any, is not to be counted unless the chairperson directs otherwise. 6. If the member makes a disclosure under subsection 4, is the chairperson, the power under subsection 5 is to be exercised by the vice chairperson. 7. If both the chairperson and the vice chairperson have made a disclosure under subsection 4 on the same matter, Section 13 of Schedule 3 does not apply to the matter. 8. The validity of any proceeding of the authority is not affected by the failure by a member of the authority to comply with this section. 9. Subsections 1, 2, 3, and 8 apply to a member of committee of the authority as if a reference to the authority in subsections 2 and 8 were a reference to the committee.
Mr. Ip Kwok Kim, I want to talk about 46(1)(b). Can you tell me more about this? A personal interest greater than that which a person has as a member of the public. On this particular point and its wording, what do you mean by greater, and what's the extent? How do you measure it? Sometimes it's public interest. So can you clarify this point? Mr. Kwok? Thank you, Chairman. As Mr. Ip said just now, yes, some interest can be enjoyed by the public. However, under certain circumstances, a personal interest may be greater than that which a person has as a member of the public. We cannot really define it here, but we have taken references from other regulators. For example, at the Communications Authorities or ordinance, we also have a similar stipulation. So I think it's a matter of judgment. That is whether that personal interest is greater than that which a person has as a member of the public, and then he will have to make a declaration. Yes, it's kind of difficult to understand. I think this will give rise to a lot of disputes. However, I don't know how you can word it more properly, but this may give rise to disputes. Yes, I understand that there are similar provisions in other pieces of legislation. Legal advisor? Now for clause 46, it says that for the matters for any matter under discussion at a meeting of the authority, but does it cover the appeal panel or appeal tribunals meetings? Mr. Kwok? This is about the authorities meeting or documents that are circulated to its members, so it has nothing to do with disciplinary hearing. So for disciplinary hearing, would you think that members of the disciplinary hearing would also have to declare their interest? According to this provision, they have to declare their interest. You can refer to clause 45. So there are already a register of interest, but the authority will formulate code of conduct, and it will be looking at different scenarios. Mr. Ip, so would you also incur 1B? Mr. Kwok. Well, when the authority formulates its rules, it will definitely take reference from this. So why will it do this in the future? Why don't you do it now so as to make it more consistent? Why don't you include it in the law? You say that for the appeal panel and appeal tribunal, the members have to declare their interest. So why can't you include it here? I think you should consider this point. I think you should include it in the law, and then it will be more consistent. We will take a look at this, and then we'll revert to members later. So that is about disclosing interest. Well, just now you say that there's a provision about disclosure of interest for appeal panel and tribunal members. Where is it? Mr. Kwok? I mean that members of the disciplinary tribunal would have to do that, and that's clause 45. It's also applicable to members of the disciplinary tribunal. For clause 25, it doesn't say that during an appeal panel meeting or appeal tribunal meeting, well, it hasn't made it explicit, but I don't think clause 25 covers that. I think the legal advisor is referring to that. These are two separate issues. Mr. Kwok, for clause 45 is about the appeal tribunal. If anyone is involved in conflict of interest, the authority will be formulating guidelines to tackle those issues. I think members are very concerned about the disclosure of interest, and this should be applicable to all the people in the authority, including the members of appeal panel and appeal tribunal. So why do you separate all these parts of the authority? The legal advisor has expressed his views. So will you go back and take a look at it again? I think members are concerned about this because disclosing interest is very important. Yes, Chairman. We will take a look at the wording again, and we will also take reference from other regulators. Now, for clause 45, Mr. Kwok said that it is required that members of the appeal tribunal would have to disclose their interests. So where is it under clause 45? where is this particular scenario covered? Mr. Kwok. Thank you, Chairman. 45(1) states that if that member is a member of the authority, then he would have to disclose his interest on his first appointment to the authority. And for subclause 2, if he is not a member of the authority, but he is a member of a committee, he should also disclose his interest. So for subclause 1, have you mentioned appeal tribunal? You're talking about 45(1). A member of the authority must disclose to the authority, and then A is on member's first appointment to the authority. So that's not the case. B, at the beginning of each calendar year after the member's appointment, and that has nothing to do with that either. And then you also mentioned bracket 2, a member of a committee of the authority who is not also a member of the authority must disclose to the authority any interest that the member has. This is also not the case. Where is the member of the appeal tribunal? Maybe I am too slow. I really don't understand. Mr. Wong, can you explain further? Mr. Kwok? First of all, we are talking about the disciplinary committee, and under Schedule 3, you can see that it's a permanent part of the authority, and half of the members have to be members of the authority. So these members are required to disclose their interests. And if he's a member of the committee but he's not a member of the authority, then in accordance with subclause 2, he still has to disclose his interests. Well, Chairman, this is about disclosable interests under 46 and is defined under 46(1). So for this disclosable interest, how can they be related to members of the appeal tribunal and a complainant, and how do you define that his personal interest is greater than that which a person has as a member of the public? Where can I find this? Mr. Kwok? Yes, I understand that members are very concerned about the closure of interest and the members of the appeal tribunal and panel. So next meeting we will provide members with a paper on this. Okay, I appreciate that. However, for part 6, yes, you may have to look at that, but you also have to look at part 5. Well, members think that there's a lack of consistency here, because for a particular provision it may be in great details, and for some other provisions it seems that people have to guess, because we are all very concerned about the disclosure of interest. Mr. Paul Chair. Chairman, I don't know if this is what Mr. Leung is concerned about, but when I look at clause 36, the definition of disclosable interest, it seems that it is not the same thing as that under clause 45. For 45(3), it states that the authority may determine the class or description of the interest required to be disclosed. So this is about members of the authority or members of a committee of the authority. So on his first appointment, he would have to disclose interest in accordance with 45(3), and the authority may determine the class or description of the interest required to be disclosed. Just for 46, disclosable interest is about meetings. That is, at a particular meeting, you have to disclose whether there are interests involved. Yes, Mr. Chair's understanding is correct. Any follow-up? If that is the case, then I might have answered Mr. Alan Leung's question. I don't know whether this is helpful. I'm just trying to give assistance so as to make things clearer. Mr. Ip Kwok Kim, Chairman. Yes, that is what I think too. For 46(1), disclosable interest, this is a definition, and then there are two provisions under it. That is a pecuniary interest or a personal interest greater than that which a person has as a member of the public. And when we look at Clause 45, it's about members of the authority, etc. They have to disclose their interest, and they would have to look at this definition. As for the disciplinary committee is 45(2). That is a member of a committee of the authority who is not also a member of the authority. So this covers all. So that's why earlier on I said that 45(1) and 2 should be combined so that it will be clearer. That is a member of the authority and a member of a committee of the authority who is not also a member of the authority. Both of them should do the same. That will be clearer.
Well, is it because 46(1) is about definition? Your understanding is right, Mr. Yip. We will consider Clause 45, the drafting, to see if we would need to amend it to make it more easily comprehensible. Mr. Alan Leung, 45 and 46 are both under Part 7, but we're talking about Part 5 and 6. When would the tribunal, appeal tribunal and the disciplinary committee to disclose interest? We'll be talking about Parts 5 and 6. So no matter how much Mr. Kwok agrees with the understanding of my two colleagues, it doesn't help with Parts 5 and 6. Well, for Part 6, Clause 38, you will see that there will be a subsidiary legislation setting out the specific arrangements. For 45, 46, it's about the interest to be disclosed by members and arrangements when interest is disclosed when it comes to participation and chairing of meetings. Mr. Leung, I thought that under Part 5, when we're dealing with members of the disciplinary committee and members of the appeal tribunal under Part 6, under what circumstance they have to disclose, they have to declare interest. That will decide whether they can participate in a hearing. For Parts 5 and 6, this has not been dealt with, but Mr. Kwok said that under Clause 38 of Part 6, the Secretary will, by regulation, prescribe the procedures. What about Part 5? Where is it dealt with? About disclosure or the need to disclose interest or otherwise. Where can I find the relevant provisions? For the disciplinary committee, it's a standing committee under the authority under Clause 45. The members of the disciplinary committee, whether they are members of the authority, will have to disclose interest. That is the arrangement under the current drafting. And if a disciplinary committee is to be formed to follow up on the investigation, there are guidelines, codes to deal with conflict of interest. Well, just now it's said that 45 and 46 are separate. Let's look at 45. Let me give you an example. There is a complainant called A. He works at the same company as a member of the authority or a member of the disciplinary committee or a member of the appeal tribunal. Then, well, in this case, I won't be able to find anything under 45 or 46. Because 46 is separate from 45, and you said 45 has addressed my concern in relation to part 5, but I can't make out the logic. Could you explain? Mr. Kwok, how is done? Let me first clarify that the disciplinary committee is a standing committee under the authority. Some members may be members of the authority, some may not. Non-authority members will have to, under 45, to make disclosures. That is a disclosure to be done as a member of a committee. I understand that in a specific case or an individual case, if there are members that have a conflict of interest, how is it dealt with? We've explained to members in the past that the authority will formulate guidelines to deal with possible conflict of interest when dealing with disciplinary hearings. And if there are conflict of interest during an appeal procedure, then subsidiary legislation will be there to cater for that. I don't really understand. Even if I accept that for Part 6, we can wait for the Secretary to, under Clause 38, to formulate subsidiary legislation to deal with the situations. Say, for example, a member of the appeal tribunal works at the same company as a member of the tribunal. Well, I don't understand. You said that the disciplinary committee is a standing committee. So what? If a complainant is now fixed before a certain disciplinary committee, which is made up of one chairman and 2 members. Is it the case that the chairman and the members can rely on the first declaration of interest made when they are first appointed to continue to deal with the hearing? When they are first appointed, they have to make declaration of interest. That is different from whether they are eligible to sit as a member or chairman of a disciplinary committee vis-a-vis a particular case. Yes, these are two separate matters. When someone is appointed as a member of the authority or the disciplinary committee, a declaration of interest is to be made. That is under clause 45. And as to whether someone can be present or otherwise in a particular hearing, the authority will formulate guidelines or make arrangements for the relevant parties to decide what to do, whether to withdraw or what. Mr. Kwok talked about a guideline. Well, under which provision in the Blue Bill does it say that the authority will formulate these guidelines, including members of a disciplinary committee having to declare interest when there is a conflict of interest with the complainant of a case he or she is going to hear? Please refer to Schedule 3, Clause 23. Nine. These committees may regulate its own procedure. So they will formulate guidelines in relation to conflict of interest. Any follow-up questions from Mr. Leung? Well, I note that, but I don't want to get in the way. Let me think about it. Mr. Porter. Just now, the answer from the government was that the disciplinary committee may have members that are non-members. Is that true? I see in Clause 23 in Schedule 3 and under bracket 5, a committee may include members who are not members of the authority. Is it the case that for disciplinary hearing there can be non-members of the authority plus one member of the authority? If we go back to several clauses, say Part 5 about the disciplinary committee, 23, it says that the authority or a committee under the authority may be responsible for, may hear a disciplinary hearing. And then disciplinary committee is a standing committee. So shouldn't all members of a disciplinary committee be members of the authority? Well, we know that under 24 it says that an authority may direct a committee to deal with the hearing under 26. But there are no details specified. Just now a member expressed concern about parts 5 and 6. If my assumption is right, the disciplinary committee comprises only of members, then all members would have disclosed interest under Clause 45 at the beginning. And an appeal, Clause 32, Part 6, when an appeal panel is formed, there will be a chairman plus 11 members. And declarations will be made under Clause 45 at the time of the appointment. So it wouldn't be the case that they need to declare interest only when they are at a hearing. And 46, about the disclosable interest, the definition. It only refers to pecuniary interest or or others as specific interest. You're not referring to the stage of appeal. For 23(5), well, when it comes to standing committee, if there are disciplinary committee, then the committee will be a standing committee, and half of the members should be members of the authority. And if it's a member of the authority, then he would have made a declaration under 45, and if that person is appointed as a member of the committee, they still have to make a declaration under 45 too. When it comes to an appeal panel, members are appointed by the secretary. They have to, under clause, the secretary will, under clause 38, set out the provisions by way of a subsidiary legislation that is in relation to declaration of interest. I know that Mr. Leung is referring to at the time of meeting. Under 23(9), it says that the committee may make its own regulations related to procedure. And for the tribunal or the appeal panel, there will be provisions made under subsidiary legislation. 38 talks about regulations for hearing of appeals. But this relates only to procedures for hearing of appeals. 32 plus 45 will give you the answer. Because at the time of when the appeal panel is formed, declaration of interest will have to be made under clause 45. Is that right? 45 is about members of the authority. 32 refers to the tribune appeal panel. They are not members of the authority, so it is not directly related. In similar regulations or authorities, when it comes to appeal panel, you will find in subsidiary legislation provisions related to declaration of interest. So in the future, there will be subsidiary legislation setting out the provisions related to declaration of interest. No, you confuse me. 45(1) it relates to members, and 45(2) refers to non-members, but member of a committee. At the time of the appointment, even if you are not a member of the authority, if you're a member of a committee, you will have to make a declaration.
If you look at 45(2), is a member of a committee of the authority who is not also a member of the authority. For 32 is about the appeal panel, and they are not members of the authority. They are to be appointed by the Secretary for Home Affairs. So clause 45 is not applicable to the members of the appeal panel. Thank you. So for clause 32, how are those members going to declare of interest? Which provision should they refer to? So they should not use clause 38, right? As I said just now, for clause 38, the Secretary may formulate appeal procedures, and in other relevant subsidiary legislation, we have seen how interest declaration can be handled. So we will also handle in the same way. So when you appoint members to the appeal panel, they do not declare at that particular stage. They will only declare their interests before a hearing, right? So for the subsidiary legislation, I think when it's formulated, it will take reference from this. And this is actually a very usual arrangement. So when you appoint members, when there is a disciplinary hearing or appeal hearing, you may summon certain witnesses, and members of the appeal panel or members of a disciplinary hearing may have to declare their interest. For example, there is a witness or an expert witness, and he may know the person, or they may even be relatives. So I think these are areas that they have to disclose. So for clause 34, for the appeal tribunal, can we add a paragraph that is, at that stage, interest should be declared? If they are already accepted as members and a hearing has started, and then suddenly it is discovered that this particular person cannot attend the hearing, then it will cost money and time. So if you are asking two individuals who are members of the tribunal to be members of the appeal tribunal, then maybe an early arrangement should be made. Before an appeal tribunal is formed, there should be such a declaration mechanism. I think these are members' views. That is, when it comes to disclosure of interest, they are very concerned about different arrangements. And the legal advisor has also expressed his opinions. Mr. Kwok promised that he will go back and take a look. Just now, Mr. Porcher also made a suggestion. During a hearing, well, sometimes it's very difficult to see things in advance. When you form an appeal tribunal, members may not know what that case exactly is. So during the hearing, members may be allowed to declare interest. Yes, the chairman's understanding is correct. When we appoint members to be members of different committees or the authority, they have to declare their interest. And also when they choose when they ask the individuals to be members of the tribunal, of course they should pay attention to their interest. However, in the course of the hearing, it may be discovered that there are conflicts of interest. So there will be rules and guidelines formulated for the appeal tribunals and panels, and then members then declare their interest at an appropriate time. So for part 6, the appeal is like this. That is under clause 38. The Secretary may, by regulation, prescribe the procedures for the hearing of appeals under this part. And then we can refer to 23(9), Schedule 3 for this. The chairman has also asked about this. That is, when can this information be given to us in writing? Thank you, Chairman. With regard to the regulation, as I said just now, because this will be prescribed by the Secretary, so we will try our best to submit this to this committee as soon as possible. But for other procedures, they would have to be prescribed by the authority, so the authority has to be formed first. We have already communicated with the industry. We have talked about frameworks and directions, so this will be given to members for reference. However, for the actual formulation, it will be done by the authority. And all this will be submitted to the electrical in due course. As for disclosure of interest, this is very important, and members are very concerned. Just now we've been discussing for a long time, and Mr. Kok may have to go back and look at some of these issues. Now it's about time today. So I suggest that we revisit these at the next meeting. For our next meeting is on the 8th of June for 30 p.m. I believe that will be enough time because we're still in early May, so you have more than 1 month. So maybe at the next meeting, we can continue to discuss this point. If there are no other business, then we will adjourn the meeting today. And at the next meeting, we will follow up on this particular point. That is about the disclosure of interest. So, any other business? Mr. Kwok, do you want to supplement? If not, then I'll adjourn the meeting. Thank you.